Do you remember when on March 20th of 2025, Stephan Sterns was actually in the courtroom? Normally he hides in his jail cell, and he was there with his defense attorneys fighting to ban the media, the cameras, and the public from any of his pre-trial hearings. Now he's got 2 trials for this year. One is scheduled for May 5th to the 21st of 2025, and those are all CSAM related charges that he's facing, and that would mean child essay material. And that is because it is alleged that he abused Madeline Soto, you can see pictured here, for 4 to 5 years, just based on the evidence they found on his Google Drive, which contained 1,700 pictures and videos of her. And let's not go over again how they identified it was him, because that's just gross, okay? So this case absolutely comes with a trigger warning.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
Then he has another trial set for September, I think it's the 22nd of 2025. And that's a homicide trial because he's accused of murdering Madeline Soto. And it was right after her 13th birthday party. She had her birthday on February 22nd of 2024. And then she celebrated her birthday on Sunday, February 25th of 2024. And then Stephan Sterns, Madeline's mother's ex-boyfriend, drove from Northport, Florida to Kissimmee to stay over. He was intending to stay for the week to help Jen Soto take Maddie to school because, you know, Jen Soto needed her sleep for her 2 days off. Yes. So anyway, there he was, and he's accused of strangling Madeline Soto. That's what he's charged with. So 2 trials, right? Now, that means there's going to be lots of hearings. He doesn't like the cameras in the courtroom. So his defense attorneys filed motions and they made all these arguments of why they should keep the public, the cameras, the media out. Well, guess what? Judge Keith Costin has come back and denied that motion. Now, I wasn't too sure what the outcome would be. We recently, actually, if you check out my community post, then you'll see that we already saw from, you know, the court filings that, okay, the judges denied it, but we didn't have the document yet. So thank you so much to Grizzly Cat and MB Inc. for sending me this. We were busy deep diving the Idaho case and reading all of those documents. And now we're going to look at this one. This one is only 4 pages long, and I have another document showing when his next hearing is. So I just wanted to read this to you as a follow-up from the hearing that we watched, because we listened to all of that, where they were saying all these YouTubers, all these podcasters, you know, all these people covering this case. I mean, yeah, a lot of people are covering this case. This is a high-profile case. But for Stephan Sterns, this is what really annoys and upsets many of us. For him to say he doesn't want cameras in the courtroom, he wants his privacy. And to think of what he's accused of violating this little girl and filming it, and filming roommates in the home that he stayed in, Jen Soto's father's home, actually, but with Jen Soto, right? He was filming the roommates under the door, obviously without their knowledge or consent. Yeah, this alleged predator, he wants privacy? Yeah, I don't think so. Keep the cameras in. So I'm so glad that this is what the judge decided. So let's quickly check it out, right? State of Florida plaintiff versus Stephan Michael Sterns. If my voice sounds a little hoarse, it's because I just read a crap load of documents in the Idaho case. So if you are following that case and you haven't checked out that live stream that we just did going over all the latest details, you can find that in the live stream section, unless I'll link it for you. I'll link it in the description box so you can watch that as well. Okay, order denying the defendants, well, let me read that slower. Order denying the defendant's motion for closure of all pre-trial proceedings. So this was filed on the 27th of March of 2025. Today's date is actually the 31st of March of 2025. Now, it says this matter is before the court on the defendant's motion for closure of all pretrial proceedings filed by and through counsel on February 18th of 2025. After reviewing the defendant's motion, the arguments made at the hearing held on March 20th of 2025, the court file and the record, the court finds as follows. I just want to say that when we watched that hearing, I see some people missed that we watched it together because I paired it with listening to one of his jail calls. So the thumbnail actually says shocking jail call and his fight to seal hearings. So that's the one, and it's linked below for you. In the instant motion, the defendant contends that there's been extensive coverage regarding the allegations in this case by television, print, and social media entities, as well as social media users all over the country and world on various platforms such as YouTube, X, Reddit, and Facebook.
So defense would argue that essentially, while pretrial publicity and the fact that there is pretrial publicity in this case, a lot of these cases that form the basis of allowing for the closure of the courtroom was pre a lot of the forms of media that we have now. TikTok, Instagram, Facebook, Reddit, podcasts. A lot of those mediums didn't exist back in the 70s and the 80s when these cases were decided, allowing for the court to allow restriction and closure. The pervasive nature of the internet itself and the exposure makes it to where the pretrial publicity, both the emotional aspect of it, should allow for this court to grant defense's motion to allow for the pretrial closure of certain proceedings subject to whatever limitations the court should impose, such as if the court were to grant closure for motion to suppress, for example, and allow at a certain period of time the allowance or the dissemination of that information, or if the court were to say motion to suppress are not allowed, no access to it, they hear it at trial. So defense would argue that defense meets the three prongs by the preponderance of the evidence, which is the standard that defense had to meet the prongs by as to each of the factors, and the court should grant defense's motion to close the pretrial proceedings.
Because the defendant expects to pursue multiple motions once discovery is completed that may require testimony and evidence prior to trial that could later be found to be inadmissible, the defendant asserts that public dissemination of this evidence during those hearings would prevent him from receiving a fair trial. Counsel for Mr. Sterns further avers that there are no suitable alternative measures to protect Mr. Sterns' right to a fair trial. Consequently, the defendant moves this court to enter an order closing all pre-trial proceedings. The Florida Supreme Court's holding in Miami Herald Publishing Co. versus Lewis recognized the presumption that the public should generally have unrestricted access to all judicial proceedings. Miami Herald Publishing versus McIntosh and established a three-pronged test to determine whether closure is appropriate and warranted. This test considers whether 1. Closure is necessary to prevent a serious and imminent threat to the administration of justice. 2. No alternatives are available other than a change of venue, which would protect the defendant's right to a fair trial. And 3. Closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Lewis at 3. As to the first prong, the factors to be considered include the extent of prior hostile publicity, the probability that the issues involved at the pretrial hearing will further aggravate the adverse publicity, and whether traditional judicial techniques to insulate the jury from the consequences of such publicity will ameliorate the problem. After considering the arguments from the parties at a hearing on March 20th of 2025, the court finds that closure is not necessary to prevent a serious and imminent threat to the administration of justice. Although the defendant proved that various news organizations, social media outlets, and individual social media users had posted numerous articles or comments pertaining to the case, the defendant failed to establish evidence that the media coverage was fundamentally hostile, or that issues involved at all future pretrial hearings will further aggravate adverse publicity. The defendant also failed to establish proof that potential veneer members in Osceola County have been exposed to detrimental facts about the case, thus tainting the jury pool from the outset. Furthermore, other alternatives such as multiple veneer panels, voir dire by counsel, peremptory challenges, cause challenges, individual questioning of jurors regarding media exposure, sequestration, and admonition of the jury are available in this case to ameliorate pretrial publicity concerns. The court is confident that these alternatives will be employed to ensure that the defendant receives fair and due process. Finally, the court finds that an order granting the defendant's motion to close all pretrial hearings would be overly broad. The defendant has not established that every future pretrial motion and hearing filed and yet to be filed will contain evidence that the public should not have access to. As a result, it would be unnecessarily broad to veil all future pretrial hearings from media coverage or public scrutiny. Based on these findings, the court will endeavor to balance the potentially competing yet fundamental rights of a fair trial guaranteed by the Sixth Amendment, the presumption of unrestricted access to public judicial proceedings, and the free press guaranteed by the First Amendment without closure. Accordingly, it is hereby ordered and adjudged that 1. The defendant's motion for closure of all pretrial proceedings filed by and through counsel on February 18th of 2025 is denied. Done and ordered in chambers at Kissimmee, Osceola County, Florida, this 27th day of March of 2025. Keith A. Karsten, Circuit Court Judge. Thank you to this judge. That must have been some bad news for Stephan Sterns on that day, huh? I was just checking because I had a feeling Stephan Sterns' birthday was sometime around now, and I'm like, happy birthday! Motion denied, cameras will be there, but his birthday is on April 25th.
Okay. How you been?
Well, had the world's shittiest birthday present, so...
Okay, now here is another document which says State of Florida Plaintiff versus Stephan Michael Sterns. There's obviously the case number. There's two case numbers. One would be for the homicide case and one would be for the CSAM-charges, right? Notice of hearing, it says, you are notified that the undersigned will appear before the Honorable Keith A. Karsten, Judge of the above-styled court on the 23rd of April of 2025 at 2 p.m. in courtroom 4F at 2 Courthouse Square, Kissimmee, Florida. Motion to suppress evidence obtained from unlawful seizure of cell phone, motion to suppress evidence obtained from unlawful searches of cell phone, and motion to suppress evidence obtained from Google search warrant. This is the defense's best bet, is to have this evidence thrown out, because if they can get that right, obviously then there's not going to be a CSAM trial. But we've listened to, although there's many divided opinions, right? We've listened to the police talking to Stephan Sterns. We've obviously listened to lots of audio files, police video interviews. We've watched all of that. And it sounded to me like Stephan Sterns gave consent for them to have his phone, keep his phone, search his phone. So let me know what you think, because I know people argue about that point. Let's see what happens on the 23rd of April of 2025. So this is obviously for the CSAM trial, which is scheduled for May 5th to the 21st of 2025.
Here's where I'm going to be brutally honest with you. There's pictures of you on your phone. And I'm pretty sure you know what some of those pictures are about. You're a very intelligent person. And I don't want you to discredit yourself by saying you don't know about all the pictures that are on your phone. You understand what I'm saying?
Should I be talking with a lawyer right now?
So that's what we have for now. It's just a small update. I just wanted to let you know that that's happening. Make sure in your calendars you put the date, 23rd of April of 2025. Hopefully we can watch that hearing together, seeing as the judge is good with cameras being in the courtroom. And let's see where the defense gets with those arguments on that day. Of course, it's very significant because, as I say, if they get somewhere, then there's not going to be a CSAM trial, and that would affect the next trial, which is the homicide one, because if convicted in the CSAM one, that will serve as an aggravating factor in the homicide trial for the state to argue that the death penalty is warranted, because yes, Stephan Sterns is facing the death penalty. Now, if you have not yet listened to those infuriating, sometimes gross jail calls between Stephan Sterns and his parents, which are only the ones from May and June of 2024, so hopefully we're able to get some other ones as time goes by. Right now that's all that the state is willing to provide, so we shall see. Yeah, go listen to those, because oh my goodness, there's live streams where I have reacted to them, and then there's also the case file that I've made for you, which is a chronological collection of the jail calls without commentary. So whichever you prefer. If you literally listen to both, oh my goodness, thank you so much. Please also like and share this video so that others can learn about this update. And I'll keep you posted on what's happening in this case, of course. I'm also still keeping an eye on what's happening with Madeline Soto's quiet teacher that was arrested also for similar type of charges. So I'll let you know what's happening there as well. There's not been too much news on that. And so in the meantime, stay safe, and I really look forward to full justice for Madeline Soto. I'm confident in the state's case, and let's see where it goes.
Grizzly, let me ask you, is it clear now from these phone conversations and the rest of the evidence that she died in that bed?
I think those jail calls are so incriminating because not only does it pair up with Jen Soto saying, I sent them upstairs, and Madeline Soto's phone showing that the data shows it went upstairs, but now Stephan Sterns literally saying, it started there. I don't know what he means by it in the jail calls, but he's saying it all started there, and then he went downstairs for a bit, and then he went back up to check on her, and she was already gone. So yes, I do think that's the most plausible scenario now, is that she was murdered upstairs in bedroom number 4.
And when we say bedroom number 4, in this house, there's multiple people, right? There's other folks upstairs. Because he's saying that he goes downstairs and leaves her up there. So I'm wondering in my mind, what could possibly be alleged during a trial? Do we know if other people were there that night?
The roommates were there in the other bedrooms upstairs. There were 2 roommates. One of them also had a son. I don't think the son was there at the time. But yeah, it sounds like he's opening the door to speculation about maybe somebody else did something to her, because he just like walked away and then he found her like that, which is just very unlikely.